Good morning, Atsana. No, it's time. It's your responsibility to explain to us about the shaping, the dynamic of current, uh, maybe geopolitical setting and its impact to the business community and also the civil society. What kinds of civil society can do in
Yeah.
order to uh, address these changes. Time and
Sure. Thanks, Daniel. And selamat pagi, everybody. It's really nice to see you all on the screen. And Daniel, thank you for the invitation to be a part of this leadership meeting. I guess, 2 days ago, I was reading an article about Indonesia and in particular about nickel mining and how there had been an explosion at one of the processing facilities and there were fatalities in that particular occasion. One of the interesting things about this particular accident is that there are likely to be many more like this that will happen over the coming years. The ban on exporting nickel has led to a boost internally within Indonesia of refining and processing nickel. What we also know is that there is a global demand for electric vehicles. And one of the key components in the batteries is nickel. So the demand is set to grow. And on the part of the Indonesian government, there will be maximum efforts in order to be able to capitalize on the global demand of nickel. So with that in mind, there come very big responsibilities for the state, for corporations involved in nickel mining and processing, but also for civil society. As there come many opportunities, these come with challenges as well. I think from the perspective of civil society, one notes that, our resources are always very constrained. Our ability to maneuver, to move, to access information, for example, relating to business activity is often very difficult. But then when you look at the state, does the state take a lot more interest in protecting people where there are more vulnerabilities, where mining encroaches on the rights of indigenous people, where mining affects workers because health and safety is not respected? Is the state stepping in to do more for people, given that the GDP or the revenues generated by this business are very important for the state? I think from Indonesia's perspective, there are ambitions at Indonesia to become an OECD country. To become an OECD country, there are several things that the government has to demonstrate. One of those is that the framework, the legal framework and the policy framework are solid enough to support the transition to becoming an OECD country. Some of you might know that the OECD countries have to abide by the OECD guidelines for multinational corporations. That has in it a series of standards and behaviors that corporates have to respect. And these are things, for example, like doing human rights due diligence, reporting to stakeholders internally and externally, providing access to a grievance mechanism that is fair and effective to workers. So this is just to say that, as geopolitics changes, as the global demand for certain minerals and materials that are richly produced in Indonesia becomes a lot more significant, so will the pressure on industry, so will the pressure on civil society to step up and to represent all those vulnerable people who might be affected by corporate activity. You find yourselves at a leadership meeting for the next day or so. And one of the interesting things I was reading a few days ago was what makes a good leader. Is a good leader someone who has all the answers? Actually, the real fact is a good leader is someone who asks the right questions. And that's what you have to remember. As leaders in the civil society space, you're not expected to have the answers to everything. But what you are expected to do is to ask questions. Ask questions of the state, ask questions of corporations, ask questions of those you are representing, and ask questions of each other. Because from asking these questions, we build transparency and we understand better how to use accountability. Globally, we see a big shift. We see a shift from initially companies would say we're doing corporate social responsibility, CSR. CSR means we build a school, we paint a wall, we do a pavement for a village. That is changing very rapidly because globally there are a lot of laws coming into force saying businesses have to recognize where they have an adverse impact on people and communities. And they have to work hard towards addressing that impact by providing access to remedy. That movement is now what is described as the business and human rights movement. And within the business and human rights movement, there are international standards, like the UN Guiding Principles on Business and Human Rights. There are all the laws, for example, European Corporate Sustainability Due Diligence Directive. Why are these important to you? You might be thinking, well, these are all European. I am sitting in Indonesia. Why is this relevant to me? A lot of Indonesian sectors, for example, palm oil, fisheries, are all producing to sell, to export to Europe. Changes at European level amongst European companies or buyers will affect Indonesian producers quite heavily. And I'll give you an example. The Corporate Sustainability Due Diligence Directive, which is currently being transposed in different European countries, is basically requires all the companies that are within the remit of the law, which is mostly European brands, to actually provide human rights due diligence systems, reporting, and access to remedy. What that basically means that if they're buying from an Indonesian producer, the producer has to be able to give evidence of how it's identifying risk and how it's managing it. That is a big consequence because the European brand cannot comply without the Indonesian partner. But that also means that if somebody within the Indonesian partner is affected by a grave human rights violation, they can now file a case or a complaint in the European country against the European brand. That is a significant change and an opportunity for accountability that CSOs have to know about and have to learn how to leverage. Similarly, the US Customs and Border Protection have this system of sanctions. If there are goods sent to the United States that are connected to forced labor, child labor, or human trafficking, the US Customs and Border can stop the goods on arrival. And then the company, to release the goods, has to show that there are no more indicators of forced labor. That is also an opportunity because as a CSO, it gives you the opportunity to file a petition with the US Customs to say this company continues to export goods that are obtained from forced labor, child labor, or human trafficking. You need to investigate it and you need to look into it. And it's a very, very popular mechanism for accountability that CSOs are using. But what's really interesting about the new laws is they envisage a different role for CSOs as well. They put out the concept of meaningful stakeholder engagement. What that basically means is CSOs can work in partnership with the private sector, with businesses. CSOs can help them to understand what their risk is. They can help them to communicate with worker populations and local communities. And CSOs can help them manage and run their grievance mechanisms better. So there is a much, much bigger role carved out for CSOs. You can either be the CSO that produces the reports, that holds corporates accountable. You can be the CSO that files claims on behalf of victims. You can be the one that files petitions with the US Customs and Border Protection to seek accountability. Or you could be the CSO that works with businesses in a constructive manner to allow them to work better with their stakeholders. It could be their workers or local communities affected by their activities. Globally, there is a big push towards this idea that responsible business conduct must be set out in global standards, not just in the OECD, not just in the UN guiding principles. So I'm part of a group of legal experts at the moment who are working with a number of states that are part of the UN, and they've gathered together to discuss creating a binding treaty. So this is a UN treaty that will put responsibilities on states so that states hold transnational corporations and local businesses accountable for their activity and their impact on individuals and communities. It's a very, very significant step forward, and it's a very important one, because actually when states are held accountable for policing business activity under a treaty, they have to do so. We all know that very often states fall behind in their duties towards their own people, towards vulnerable people, towards local communities, towards workers. And that very often it becomes the job of CSOs to really lobby the state to take more action and be a lot more engaged in holding businesses accountable. And that is also a very critical function that CSOs provide. In terms of some of the other developments globally, aside from the regulations that are coming, by the way, not just from Europe, they're coming from the United States. They're coming from Canada, Mexico, Australia, potentially the United Kingdom soon as well. So this really is a movement on a global level to hold states accountable for protecting vulnerable people and respecting the rights of people and providing access to remedy. But there's also a global push towards businesses being held accountable for the adverse impact that they might cause on individuals and communities. Now, in terms of case law, what have cases been telling us globally? We see that there's a lot more appetite and interest in global courts to hear cases. So, for example, recently there were cases heard in the United Kingdom against a British company about violations that happened in Malaysia at a local supplier that was supplying to the British company. So you start to see how violations in a part of the world can now be heard by a court in another country, or where the parent or the brand is domiciled. That is a growing trend. We see a lot of supply chain type cases that are now being heard in different parts of the world where violations happened in an entirely different place. We see that there are a lot of complaints being filed, for example, in Germany. Germany passed the supply chain due diligence law over a year ago. And now in the past year or so, we've seen complaints filed by CSOs, by other interested parties with the German regulators to say this company is not doing its human rights due diligence correctly. So the cases can be for victims' rights and remedy, but they're also about the way businesses run their business and do their due diligence, etc. What is interesting about all of these changes is that it's creating a lot more transparency globally. So companies are being required to report on their human rights due diligence efforts. So it's a lot more transparent what they're doing, what they're not doing. They're also being told you have to give a sense of how effective these systems are. Do these work? Do these not work? I know in Indonesia recently, the government introduced Prisma, which is a system of self-evaluation where companies can do self-evaluation. They put in their details. There are a series of questions around environmental, social, and governance indicators. And then they get a score of whether they need to do more, what areas they need to do more work on, and what that is. That is still a very much a voluntary approach. And there is a need for something which is a lot more stringent than that, so that the level, there is more of a level playing field at a local level. As advocates, you will notice that the local laws are often fall below compared to international standards. That's a reality with which we work with. And it's something that really needs to change over time. So with all of these changes happening at a local and at a governmental, at an international level, what are the opportunities and the demands on leaders like yourselves in the CSO community? One is I would recommend that you take advantage of the stakeholder engagement requirement of these regulations and look to be involved with businesses, maybe in not just in a sort of an accountability role, but also in a constructive engagement role, where you're perhaps working with them on socializing the grievance mechanisms with beneficiaries. You're working on helping beneficiaries put cases forward through the grievance mechanism. You're working with businesses constructively to help them identify areas where they can improve and they can do better at their human rights due diligence and access to remedy. The second thing you could do is perhaps be a lot more forthcoming in using international mechanisms for accountability that are available, whether these are through sanctions tools like the the US Customs and Border Protection petition system, whether this is through filing complaints with OECD mechanisms of different countries where the brands are domiciled, whether it is approaching financial institutions that are banking some of these private businesses that are committing acts of human rights violations, or whether it is using the mechanisms provided by the new regulations that are coming into force. The opportunities are multiple, but you're also faced with resources constraints. You're also faced with, the need to upskill as well. You also need to stay on top of a lot of these changes so that you can use these better. So this is all to say that, the geopolitics landscape is constantly evolving and changing. There's supply and demand globally for certain minerals, for certain products and commodities, also influences the way the state behaves, the way the state invests, and how it chooses to perhaps engage with civil society or not. But the job remains to be done. There are a lot of vulnerable people and communities who are affected by the work of businesses. And your job as leaders in this space is to ensure that the state is mindful of its role to step in and respect, protect, and remedy rights, and that corporations are there to respect and to also provide access to remedy. It is a very, very important role that you play, and it's a role that is fraught with its challenges, but that also brings a lot of opportunities. So I wish you all the best in your endeavors. And just to say that, the world is changing. It is very important that the CSO community continues to grow, to evolve, and to adapt to the changing landscapes and to the demands of times. Our job is to ensure that those in positions of responsibility remember that the risk to people and planet is the biggest risk to business. And all of that needs to be reflected in the way that business and states go about running their business and running the state. But let's talk about the binding treaty first. I think it's important to know that this binding treaty has been in discussions for the last 10 years because the states cannot agree on some of the core concepts. So one of the things that is really problematic in the drafting and discussions right now is what is the scope of the treaty? Initially, when the idea was put on the table, it was only meant to apply to transnational corporations. So these are businesses that work in many countries. But now there is a proposition that it will also apply to local companies as well. And that's a big game changer. If this gets agreed upon, and there's actually a discussion later this week at the UN between the states on these issues, I think this will be one of many discussions to be had. We are still a long way from having a legally binding treaty on multinational liability. And therefore, we are far from getting to a point where Indonesia is going to have to ratify that. We are very far from that because we are not close to having essentially an international binding treaty. The discussions are ongoing. There is a lot of differences between the states. One of my jobs is to actually advise the states on issues like rights of remedies, rights to remedy for victims, and access to remedy issues, etc. So that is something that you need to bear in mind. We're far from it. When it comes to the EUDR, the EUDR is very focused, as you said, on agricultural commodities. And, mining is not a part of it, but mining, will be caught by CSDDD because the Corporate Sustainability Due Diligence Directive doesn't relate to a particular sector. It's wide, and it's about human rights due diligence responsibilities normally. In terms of the EUDR, it's been postponed by 1 year because it was recognized that producing countries are not ready to comply with the EUDR. I think perhaps the hardest hit are going to be smallholders who are going to be expected to provide compliance, etc. The EUDR has some provisions around remedy. So the actors in the supply chain, for example, the brands, will have to make access to remedy available to across the supply chain. With all of these laws, whether it's the EUDR or the CSDDD, the ambition is that we have better balanced supply chains. So if somebody is in a country where access to justice or access to remedy is not good, they can use remedy provided in the country of the buyer in order to be able to make good some of these violations. It's called creating equity through the value chain, a bit of a rebalancing exercise. So, of course, this doesn't help a smallholder that has to provide all sorts of compliance that they don't have the financial resources to do, they don't have the capacity to do. But what these CSDDD, for example, says is that the brand has to pay so that the suppliers, the producers, the smallholders are able to provide this kind of compliance and better systems of grievance, etc. So the overall ambition of these laws is that there is greater transparency, greater accountability, but also that actors across the value chain are in a better position to step into their role, to take responsibility and provide remedy to people. Whether this will happen is very debatable, because I think we will have a few years of issues with trying to get compliance before we get to a better position. And finally, the Indonesian system, like many other systems, isn't always friendly to those whose rights have been exploited or abused. It's nothing new. It happens in many countries globally, including many countries in the global north. However, the regulations are bringing with them greater focus on grievance mechanisms, greater focus on access to remedy, greater expectations and standards around remedy. And that will provide better opportunities for people to have better systems through which to access remedy, but also a better quality of remedy. As for state-based systems, I think it's going to take a few years before we really start to see the influence on regulations and how the regulations can really improve the quality of rule of law in any different country.